Welcome to TCPA Audit. The narrator of this video is not an attorney, and nothing in this video is legal advice. This video only contains the musings and thoughts of a non-lawyer. The purpose of this video is for entertainment and to provoke thought. You should not assume anything you hear in this video is true. The narrator of this video's thoughts and opinions might well be wrong. If you find anything interesting in this video, you should research it yourself. In case you missed it the first time, the narrator of this video is not an attorney, and nothing in this video is legal advice. Please don't ask the narrator of the video for legal advice or to answer legal questions. Only lawyers can give legal advice, and the narrator is not a lawyer and can't comment on your situation. If you would like the narrator to comment on telemarketing-related public information, such as a court opinion, please email tcpaudit@proton.me with a link to the public record, and why you think that public record merits a closer look.
In part one of this four-part series, we went over Vivint's motion to dismiss. Vivint made some legal arguments that I'm not going to cover, but the gist of their motion to dismiss is that a couple of these plaintiffs have filed some TCPA lawsuits before, and they have some different phone numbers, and like a lot of telemarketers, they feel like if a plaintiff has sued more than a couple of times, they just shouldn't be able to sue anymore. It's not an argument I've seen win in any court generally, but when a defendant doesn't really have any arguments, then I guess bad arguments start looking more attractive. I'm not going to spend a lot of time on this lawsuit or this response. I'm going to scroll through most of it. One of the things I talked about in the Ken Johansson series is that, I just didn't see him playing any defensive ball. And one difference I see with these plaintiffs is they did play defensive ball. After they took the calls and after they found out who was behind them, they followed up with do not call requests. In the case of one of these plaintiffs, he had already made a do not call request, apparently about a year before. He was or should have been already on their do not call list. So I'm not suggesting that the court here was biased against the plaintiffs in any way, but the reality is we don't know. If a plaintiff plays defensive ball well enough, even if a court is biased against him, the court's probably going to feel a lot of pressure to just follow the law, independent of their own personal feelings. And these plaintiffs did a pretty good job of making it so that finding against them would have made the court seem unreasonable. So no idea what the court's personal feelings were in this case, just recognizing the plaintiffs played defensive ball and they're going to have a victory in the end. So just scrolling through, they talk about how the Vivint tried to paint them with this professional plaintiff paintbrush. They didn't have any evidence to make these claims. They just hope that if they throw enough stuff at the wall, something's going to stick. And as I said, I'm going to scroll through this case, this response pretty quickly. But here's Mr. Perong playing defensive ball. Here's Mr. Cunningham playing defensive ball. And I would encourage anyone to pull the briefing on this case or any other ruling that the ruling is interesting to them. I encourage them to pull the briefing and see, what resulted in that favorable or maybe unfavorable ruling. One of the things I like about the plaintiffs in this response is they talk about the intent of the TCPA. Congress enacted a private right of action to encourage the average Joe to pursue his rights in court when he's harmed by these illegal calls. They talk about how, something to me that pretty much separates the sheep from the goats in these illegal call lawsuits. If a caller feels like they have to spoof their caller ID, I mean that to me is the whole ballgame. Why would a telemarketer who's on the up and up and thinks they're following the law spoof their caller ID? The only reason you're going to spoof your caller ID is when you know you're doing something illegal and you don't want to get caught. The TCPA has identification requirements. A lot of state laws have identification requirements. Telemarketers have to tell you who they are, who they're calling for, and things like that. So in a case like this, where a defendant won't identify themselves, well, to me the inference is, I know I'm doing something wrong and I don't want to get caught. Otherwise, you're going to be proud to get your business name in front of consumers. If a company is not proud to get their business name and their contact information in front of consumers, the only reason they wouldn't do that is they're afraid that they're going to get caught because they know they're breaking the law, in my personal opinion. I'm not a lawyer, but what other reason would a legitimate company have for not identifying who they are? They go to beat down this argument. This is an argument that I've seen a few times. I haven't seen it a lot, but I'm glad these plaintiffs went to beat it down. Is that, hey, if we illegally call you, you need to hang up so quickly that you can't identify who we are and sue us. And if you don't hang up really quickly, if you stay on the call to identify who we are, well, then you wanted the call and now you can't sue for the call. So, of course, that would be a great victory for illegal telemarketers if they could make that stick. I haven't seen it stick. I haven't seen it tried a whole lot, but I'm glad that these plaintiffs spent some time to beat this argument down. I believe that I have more highlighted text on where they beat this down. I like this section of the response. They bring up some case law where a number of judges have ruled that just because a pro se plaintiff knows how to take you to court doesn't mean that they've lost their right to privacy. It doesn't mean that you can just keep calling them illegally because suddenly they don't have any privacy rights. This is a pretty popular argument with telemarketers. I've not seen it win. Well, in the one case I saw it win. I saw it was overturned on appeal. But it's an argument. It's a losing argument that I see very frequently. Again, I guess when you don't have any good arguments, bad arguments look better. This Stoops case should be an episode all to itself. They try to paint these guys with the Stoops paintbrush. It doesn't work. I also like a couple of May cases. Should cover those in some episodes. I love how the plaintiffs here bring up more of their playing defensive ball. Text message solicitations after the lawsuit was filed. Again, let's say that this court was biased against these plaintiffs. How can the judge use the fact that Vivint continued calling even after being sued? How can a judge still say these plaintiffs are in the wrong? Hard to do. Apparently, a Mr. Abramson has filed more than 300 lawsuits to vindicate his rights under the TCPA. I went and I pulled this Abramson case and I pulled the briefing. I'm not sure where they got the claim that he had filed more than 300 lawsuits. Maybe they just did a Pacer search, which I didn't do. But that does not seem to be argued in this decision. But I'm going to assume it's true because these plaintiffs seem pretty credible. And so, I think the plaintiffs in this lawsuit are kind of rank amateurs. If this other fellow has filed 300 lawsuits and no one has been able to make a professional plaintiff argument on him. this whole characterization of operating a TCPA litigation business. So I guess if you sue too much, defendants claim that that's operating a TCPA litigation business, and but I haven't understood the logical connection between operating a TCPA litigation business and not having any privacy rights. Who gives up their privacy rights just because they sue over their privacy rights? What other genre of lawsuits related to living do you give up your rights after you sue too much? I can't imagine a bar bouncer. Bar bouncers, it seems to me, must take a fair number of punches and things like that in their line of work. I can't imagine a bar bouncer taking a punch and then suing the guy that punched him, and then the defendant saying, well, you operate a bar business, just taking punches is just part of your job. You can't sue me for punching you. Like, that defendant would get laughed out of court if he tried to throw out the bar bouncer's lawsuit with that argument. But these TCPA defendants try to make this argument stick. There's a few judges that, I guess there's at least one judge out there that's receptive to this argument, and those judges just need to be appealed until this argument just isn't respected by anybody. Scrolling through to the end, I'm not sure if I had anything else highlighted. So nothing else is highlighted. The next video we will cover Vivint's reply, and then we will look at the order. The court's order in this case, I think, vindicates these plaintiffs very well.